Telangana State Governor Dr. Tamilisai Soundararajan's recent allegation of her phone being tapped has created a stir amidst her ongoing rift with the state government.
My phone is taped. My privacy is interfered.
Tamilisai has had a running battle with Chandrasekhar Rao's TRS government ever since she assumed power as Telangana governor. In September, she accused the state government of discriminating against her by not following protocol.
I was denied the governor address. I was denied hoisting the flag on the Republic Day. And even now, wherever I go, the protocol is totally not followed. I am not attended, the collector doesn't come and greet us. And I am not bothered, but the office should be respected. So definitely there will be, in the history of Telangana, a governor office, a governor is treated like this.
In the recent session of the Telangana State Assembly, 8 bills were adopted and forwarded for governor's assent. Of the 8, the governor gave her assent to only one bill, which is the Telangana Goods and Services Tax Amendment Bill 2022. The governor keeping bills pending and not giving her assent to them has raked up a controversy, with the government objecting to her attitude. However, in a press conference, Tamilisai denied all claims of the government and said she wanted only clarification regarding the bills, especially on the Telangana University's Common Recruitment Board Bill 2022.
The first bill I should deal with, I thought, the Common Recruitment Board Bill. And when the government wanted to form another new board, so I wanted some clarifications. And it was projected as if I am halting the process of recruitment, and as I am blocking the process of recruitment, what type of activity and how it is formed, and what procedure is going to be formed, what procedure is going to be followed, nothing is there. A single word they will write a bill and I have to endorse it. I have the right to assess it. That is what the people. I want justification because the correct persons and the eligible persons should be recruited. It should not be a party-oriented recruitment.
Tamilisai also sent a letter to the state government to send Education Minister Sabita Indra Reddy, who would meet her on November 9th to explain the bill on Common Recruitment Board for universities. In an extensive interview with TNIE reporter VV Balakrishna, the first Advocate General of Telangana, K. Ramakrishna Reddy, comments on the do's and don'ts of both the governor and the state government with respect to following protocols.
In states like Tamil Nadu, Kerala and Telangana, there are confrontations between the governor and the state government. What is your opinion on this? Who is right and who is wrong? What the constitution says on this?
The constitution says on this, governor will have an executive power under the constitution. Under his name only, the orders will be pronounced. All orders will be issued. That is a normal routine executive power of the governor. But secondly, you see, now issue is, now the governors Kerala, in Telangana, or somewhere in Tamil Nadu, these governors are now, they are not assenting the bill. See, as you know, in Telangana, where it appears that there are a number of bills are pending with the governor without any assent. So that under Article 200, the governor has to examine. Suppose if they are not, if the governor is not required, he is not interested, or he is feeling some difficulty, he can discuss with the concerned department, concerned secretary, and say these are the lapses on the bill, these are the illegalities on the bill. Therefore, that I am remitting the matter again to the legislature, reconsider it. With appropriate note, she must send it. Instead of that, keeping the bills with them, asking the ministers to come to Rajbhavan and discuss the bill is not proper. The governor is not super auditor of on the state government. Suppose any bill passed by the state legislature, they forward it to the governor for his assent. Governor has to examine. Suppose sometimes the governor feels this particular law, the particular bill passed by the state legislature, is contradicting the parliamentary legislature. Then the governor can obtain an opinion, Attorney General or a Solicitor General, or the governor feels that the bill is contradicting the parliamentary laws or some other statutory objections, the governor can reserve the bill and forward it to the president for his assent. So suppose even a president feels that the assent is some objections are there, the president will also remit the governor in turn with the same objection to remit the matter to the state legislature, state government. Then with that objections, the legislature may pass, may not pass. Sometimes that objections raised by the governor, objections raised by the president, they may not be valid, sometimes political consideration. Therefore, the state legislature again passes the same bill, then that bill has to be necessarily has to be assented by the governor. In this respect, governor is in a very, very nominal, little powers, except examining the matter whether the particular act is illegal or not, particular act is in accordance with the constitutional provisions or not, the particular act is contradicting the union legislature or not. On these aspects, you can examine and discuss with the concerned with state government, can take appropriate action. That is the general governor power on the legislature.
Inviting or summoning the particular minister to Rajbhavan, is it acceptable?
That is also not correct. Why not? Sometimes you see what minister will say. The minister says, the legislature, majority members of the legislature passed the bill, we have forwarded to you. So for is the signature.
Yes,
the
sir.
governor's duty to examine that particular bill and to take necessary action in the matter. The particular minister says the bill is valid, bill passed by the state legislature. Therefore, please assent that bill. The minister will say only like that only. Suppose he is having, governor in office is having an objection. See, that objection has to put it in a form and remit the matter to state government for reconsider. Legislature, I can put it legislature.
Yes, sir.
Asking the legislature to reconsider the matter.
Sir.
Suppose the legislature will not consider, may consider with appropriate amendment, or may not consider without amendment also. Since the bill again resubmitted, governor has to sign on that bill. The governor has to give assent on the bill under Article 200 is a mandatory. Second time. That then why calling the particular minister? What particular minister will say? In our case in Telangana, now I read in the newspaper, the governor is called the particular minister. Minister will come. She may not have what the particular minister.
Naturally, the minister will defend her own bill. That's the point.
And not only defend the bill, what minister will not say? The minister will say the majority members of the legislature passed the bill.
Yeah.
It is in the public interest, government policy, and government wanted to bring the measures or reforms. Therefore, we passed on the bill on the particular subject. That's all she will say. Already that I stated in the memorandum of the bill.
Objects, aims and objects.
Aims and objects bill. The minister will say same. In Kerala also, I read in the newspaper, governor is calling the minister, come and discuss with me. Like they are not super bosses over the state government. Their governor, of course, is a respectable person, is a constitutional functionary, and all the laws and will be enacted in his name, and they must do it. Only this is a legislative business. The bills are against the laws. Bills are contradictory to the particular provisions of the constitution, are contradicting to the union bills for the laws passed by the parliament. Well, to that extent, the governor has to examine.
In Telangana, the governor is very active and holding Praja Darbars. What the constitution say on
Praja Darbar is for popularity's sake. They will conduct the Praja Darbar. All right, the governor will receive the representation. What governor will do after receiving the representation? The representation will be marked to the state government or concerned department to take appropriate action. But he or she cannot give direction saying you must do this, you must do that, you can appoint or you can not to appoint, you can pass this, you can give that order. Governor cannot say like that. See, only governor can say remit the forwarding the representations to the appropriate, the concerned departments to take appropriate action in accordance with law as early as possible.
When there are conflicts between the governor and the state government, how can they be resolved?
Suppose now, for example, the state of Telangana forwarded the bills. The governor is not taking any action. Then the state government will represent to the President of India. The President of India is appointing authority of the governor. Who will appoint the governor? The President of India will appoint the governor. then the matter will be brought to the notice of President. Sir, we passed the bills. The state governor is not taking any action on this matter. Naturally, this President has to take appropriate action in the matter.
After the gap was widened between Rajbhavan and Pragati Bhavan in Telangana, the government is not extending protocol to the governor, more particularly during their visits to the various places in the state.
That is not correct.
Yeah.
That is not correct. See, when a governor goes to the state, the different parts of the state, normally Rajbhavan will communicate the program of the governor. The concerned state government, or chief secretary, or the appropriate authority, they must see that the appropriate what is the privileges, whatever the courtesy has to be extended to the governor. If that is improper on the part of the state government, they are not extending the protocol, whatever it may be, the appropriate arrangements to the governor. Necessarily, the state government, concerned department has to extend all the protocols to the governor.
Not extending protocol to the governor is a violation of the provision of the constitution, sir?
It is improper, I can say. Not violating the provision, it is improper. It will project the state government is improper. The governor also can bring to the inappropriateness to the President of India. But on that ground, there is no action, there is no law laid down by the High Court or Supreme Court. But necessarily, the state government has to extend all the courtesies and protocols to the governor.
The TRS government, quoting Prime Minister Narendra Modi's speech as Gujarat Chief Minister earlier,
No, that is not correct.
says that governor's post is a residual of colonial system and not necessary.
No, residual. Maybe residual. The governor post of the governor or institution of governor was existing in 1935 Act also. Because the President of India, that means central government, will administer through the governor only. The governor is a linchpin, the connecting to the central government and state government. The everything is colonial system. The chief minister, ministers are also colonial system. Cabinet system of the government is a colonial system. The British government was evolved with it. With the modification we are following.